Hi there, contract students, and welcome back. Morty says hi as well, right buddy? To our fourth lesson on contract interpretation. If you want to follow along at home with notes, illustrations, and examples, you can check out my slide book available at the link below. But for this lesson, what you really ought to do is go on Westlaw and download the full cases for CNA Construction Co. versus Benning, which is going to be at 509 Southwest 2nd 302. It's an Arkansas case from 1947. And Pacific Gas and Electric versus G.W. Thomas at 442 P 2nd 641, the Pacific Reporter. This lesson is really about determining ambiguity in contracts. In prior lessons, we explored whether there really is such a thing as objective meaning. And we discussed the difference between intrinsic evidence and whether courts will admit, sometimes or always, extrinsic evidence when interpreting contract language. Regardless of your jurisprudential disposition as to whether you take the objective or subjective view, you could side with me on the subjective side or have better company, I'm sure, with Oliver Wendell Holmes and others on the objective side. But many have espoused both these positions, and quite frankly, you have to be able to relate to both of these positions. You may have to contend with an adversary that argues one policy or the other, and you may encounter judges that have different perspectives as well. So in this fourth lesson, we'll focus on what to do when a contract term is not obviously ambiguous on its face, but a party seeks to introduce evidence of extrinsic evidence, that there is a latent ambiguity, basically suggesting that while the term may not appear ambiguous, while it's not patently ambiguous, can we argue that it's latently ambiguous? A term is considered patently ambiguous when the intrinsic evidence, the four corners, show that there's a lack of clarity, but some courts will admit extrinsic evidence to show there's a latent ambiguity. That's more on the subjective view of contracts. To frame the question in a third way, when can extrinsic evidence be used to show that a written contract is ambiguous? In a previous lesson, we read the Clapp case, which showed that courts can and do disagree about whether contract language is ambiguous or clear. We're not talking about that today. We're not talking about the Clapp example of disputes about whether something's patently ambiguous. Today, we're talking about cases where there is no patent ambiguity, but maybe a latent ambiguity. We're going to read the CNA and PG&E cases for two different perspectives, leading to two different rules on admissibility of extrinsic evidence to show a term is ambiguous. We'll start with CNA. And in CNA, Justice Holt takes an objective approach, holding that if a written instrument contains clear and unambiguous language, it's the court's duty to construe it according to its plain meaning. In PG&E, on the other hand, Justice Traynor takes a more subjective approach, holding that language is inherently ambiguous and therefore extrinsic evidence is virtually always admissible if the offered evidence is relevant to prove a meaning to which the language of the instrument is reasonably susceptible. So those are our two perspectives. What reasoning supports these two different perspectives? Well, on the one hand, the objective theory, as espoused here by Justice Holt in the CNA case, provides incentives for the drafter to use clear language, promotes speedier and easier trials, and promotes reliance on the language in the contract. Therefore, extrinsic evidence shall not be admitted where the intrinsic meaning is clear and unambiguous. That's the objective, also known as the formalist approach, Justice Holt. On the other hand, the subjective theory, as espoused here by Justice Traynor in the PG&E case, and by the way, in the CNA dissent, but here on the PG&E case, we focus on the intent of the parties. And this justifies the admission of a much broader range of extrinsic evidence. So the court can actually determine what the parties intended for their own contract. Now, admittedly, this approach is criticized for undermining the certainty and finality of written agreements because it, in a much wider range of circumstances, will permit challenge to the meaning of well-drafted and clear terms. So now that we understand these rules, let's apply them to the facts of the cases. First, let's analyze the facts of CNA. That case involved a contract for the installation of sewer lines. We begin our analysis by looking at the contract language. In CNA, the contract said, and I quote, "It is further agreed that the second subcontractor will receive $20,000 for supervision. which will be added to the actual cost figure. The second subcontractor, which was Benning Construction Co., sued CNA, claiming that CNA underpaid Benning by some $55,000. Now, the jury didn't award $55,000. The jury awarded $40,000, of which $18,600 was for salary and living expenses of Benning's on-site supervisor, and an additional $20,000 for the supervision. CNA appealed, claiming that salary and living expenses of the supervisor is defined as part of supervision, so Benning got double recovery. Morty, what? Benning counterclaimed that the salary and living expenses is part of actual cost, so the award was appropriate. So the question is whether salary and living expenses of an on-site supervisor is part of supervision or actual cost. What do you think? Benning sought to introduce extrinsic evidence supporting its position. First, during preliminary negotiations, the parties apparently discussed that salary and living expenses of the supervisor would be an actual cost. And so that would indicate that they had extrinsic evidence of preliminary negotiations that this payment was required. Second, apparently the trade usage, the uses of trade in this industry, was to charge a supervisor's salary in addition to a fixed fee for supervision. And then a third piece of trade usage evidence. The American Institute of Architects has a standard form contract that says cost to be reimbursed could include payment of salaries for on-site supervisors. Will a court hear this extrinsic evidence? Well, remember that in CNA, the majority opinion written by Justice Hull, we strain the plain, obvious, and unambiguous language and refuse to hear extrinsic evidence where there's no patent ambiguity. The CNA court then finds the contract provided the CNA court would find that the contract provided a guaranteed profit of $20,000, but no additional compensation. It reads the language and it says supervision is supervision, and there is no additional payment for the living expenses of the supervisor. The CNA court determined this based on their own reading of the contract, on the plain meaning of the terms, and refused to consider extrinsic evidence. And so it modified the judgment, wiping out that $18,600. Now the dissent, which is similar to the majority in PG&E, written by Justice Fogelman, distinguished between the two types of ambiguities I alluded to, suggesting that they were patent ambiguities, where the document is unclear on its face, and both the majority and the dissent seem to agree that there's nothing patently ambiguous about the contract, although I'm not so sure. In any event, Justice Fogelman points out that there are latent ambiguities in all contracts as well, and a latent ambiguity is defined to mean an ambiguity which arises not upon the words of the instrument, as looked at in itself, but upon those words when applied to the object or the subject which they describe. It is one which does not appear on the face of the language used, or the instrument being considered, but some extrinsic fact or evidence from another source creates a necessity for interpretation or a choice among two possible meanings. The CNA dissent, therefore, would have admitted the extrinsic evidence to determine whether or not the contract had a latent ambiguity, and potentially would have allowed Benning to prevail. Benning here alleges that the parties, as I mentioned, discussed paying salary to the supervisor, $300 a week in salary and $50 a week in living expenses, and those preliminary negotiations were to be in addition to the $20,000 guaranteed profit. Well, that evidence would tend to show that supervision did not include these costs, and these in fact were part of the actual costs. But is that extrinsic evidence of preliminary negotiations going to be admitted? Not according to the CNA majority, but yes, according to the dissent. By the way, I think the CNA court misunderstood something about corporate law, which I also teach, so I'll take a minute to digress about that. You see, Benning's supervisor, who was to receive the salary, was also the president and sole shareholder. That means that the supervisor would get the salary of the supervisor and effectively get the profits of the company when the corporation made its stockholder distributions. I think the court saw Benning and its supervisor as essentially the same person, because it was a closely held corporation with effectively one owner, and therefore found that the payment of profit plus salary and living expenses was duplicative. But I think this is a fundamental misunderstanding of corporate law. You see, under corporate law, a corporation is a separate legal entity from its shareholders. And so even though Benning was the sole shareholder, the corporation really is a separate entity from Benning. Profit to the corporation is also not the same as salary to the president of that corporation, or to its sole shareholder, or to its supervisor. Again, because they're separate entities, and there are tax reasons for that as well. So, okay, maybe the legal fiction of the corporate form should not compel an alternative result, but I have another way to frame the argument that I'm making, in that CNA also misunderstood the business reality here. In this case, Benning was a very small company where the sole shareholder was also the president and its supervisor, and that seemed to lead the court to feel that there was a duplication of payments to the supervisor and shareholder. But what if Benning wasn't so small? What if it was a really large corporation where the supervisor and the shareholders and the president were all different people? Would that change the result? Should that change the result? It seems that CEA would think so, that the majority would pay $38,600 to a large corporation, which hires a professional supervisor who is not the shareholder, and would only pay $20,000 to Benning. To my mind, that doesn't make sense. There's no good reason why CNA should pay less to Benning than it would to a larger corporation. I also don't think CNA would have expected to get that result, and so I think that the CNA court, by holding to an objective view of contracts, effectively gave CNA a windfall. But then again, I've already expressed my support of the subjective view, and I will admit that in many cases, the objective view gets to the right result with a lot less expensive litigation. Speaking of the subjective theory, let's turn to the second case, PG&E, which has an opinion by Chief Justice Traynor. And in this case, Justice Traynor espouses the subjective theory of contract interpretation and bases this on the idea that contracts and language itself is inherently ambiguous. And this leads to much greater admissibility of extrinsic evidence. The PG&E case concerned a contract where G.W. Thomas, Drayage and Rigging Co. Drayage is like short-term logistics, short-distance transport. And G.W. Thomas was going to furnish labor and equipment necessary for the removal and replacement of the upper metal cover of PG&E's steam turbine. PG&E is a power production company. The contract said that G.W. Thomas would perform the work, quote, on its own risk and expense, and that G.W. Thomas would indemnify PG&E against all loss, damage, and expense and liability resulting from injury to property arising out of or in any way connected to the performance of the contract. G.W. Thomas also agreed to obtain at least $50,000 in insurance to cover liability for property damage. Well, as you probably guessed, the work did not go as planned. The metal cover fell and it damaged the steam turbine. PG&E sued G.W. Thomas for the damage, and the jury awarded the amount of around $25,000 to PG&E for the damaged turbine. This holding was based on a plain meaning interpretation. After all, the contract said G.W. Thomas would bear all the risk of such damage. In other words, the contract was patently unambiguous. On its face, it was clear. But was there a latent ambiguity? And will courts hear extrinsic evidence of a latent ambiguity? Well, G.W. Thomas sought to introduce extrinsic evidence, including preliminary negotiations, course of performance, and other proof that the indemnity clause was only meant to cover, get this, the indemnity clause was only meant to cover damage to third parties, and not intended to cover damage to PG&E's turbine. That's not what the contract says in its face, but is that what the parties intended? While the trial court seemed to agree that the contract did have classic language for a third-party indemnification, it nevertheless held that the plain meaning of the contract was that G.W. Thomas indemnified PG&E. In other words, the trial court is abiding by the objective theory of contract interpretation and thereby refuses to disturb the plain meaning by hearing evidence about latent ambiguity where there was no patent ambiguity. Okay, having determined that the contract had a plain meaning, the trial court is compelled to arrive at this conclusion. No extrinsic evidence can be admitted, and we're going to interpret the contract according to its plain terms. The plain terms, according to the court, say that G.W. Thomas will pay for any damage, and therefore they pay $25,000. The Supreme Court, however, took a different approach. In a majority opinion authored by Justice Traynor, the court held a different rule, namely, it held the following, quote, "The test of admissibility of extrinsic evidence to explain the meaning of a written instrument is not whether it appears to the court to be plain and unambiguous on its face, but whether the offered evidence is relevant to prove a meaning to which the language of the instrument is reasonably susceptible." That's the subjective theory. Why does the court take a more subjective view of contract interpretation? Perhaps because contract language is inherently subjective by its nature. Quoting Professor Corbin on contracts, the court finds that when a court interprets a contract, it determines the meaning in accordance with the judge's own linguistic education and experience. In other words, all contract interpretation is subjective, at least insofar as a judge brings his or her own meaning to bear on the terms of an agreement. Oh, sorry, scared the dog. Justice Traynor, does the subjective theory scare you? No, he's good with it. Justice Traynor dismisses the objective theory as a remnant of a primitive faith in the inherent potency and meaning of words. Under the objective view, Traynor argues contractual obligations flow not from the intention of the parties, but from the fact they use certain magic words. That's fairly derisive language against the objective view, saying that we're ignoring intention and focusing on magic words. By pretending that certain magic words have inherent objective and unambiguous meaning, evidence of the party's intention therefore becomes irrelevant. But words, according to the subjective theory, don't have an absolute and constant meaning. Rather, a word is a symbol of thought and has no arbitrary and fixed meaning. Isn't that right? Traynor reasons that the intention of the parties, as expressed in the contract, is the source of all contractual rights and duties. Therefore, a court must ascertain and give effect to the party's intention by determining what the parties actually meant. It has to get into their minds. That's the meaning of the subjective view. What do they actually intend? So contractual interpretation requires at least a preliminary consideration of all the credible evidence offered to prove the intention of the parties, including the circumstances surrounding the making of the agreement. So, the court's job in the subjective view is to place itself in the same situation as the parties found themselves at the time of contracting. Accordingly, the PG&E court finds that the lower court's refusal to admit extrinsic evidence was an error. The extrinsic evidence, particularly the fact that the contract language is prototypical of a third-party indemnification clause in this use of trade, and that preliminary negotiations indicated that PG&E did not expect to be indemnified by G.W. Thomas, that shows that the term in question really is reasonably susceptible to G.W. Thomas's meaning. Moreover, this evidence persuades the court that the parties did not intend for G.W. Thomas to indemnify PG&E. And therefore the judgment must be reversed because it does not reflect the intention of the parties. Of course, reasonable people can disagree about what approach is better. Judge Kaczynski criticized the PG&E decision, and he said its rule would, quote, "cast a long shadow of uncertainty over all transactions and leads only to the frustration and delay of most litigants and clogs already overburdened courts." That's a pretty good reason to take the objective view. Justice Most, who actually had joined the PG&E majority in the case we just discussed, later had a change of heart. "I had misgivings at the time," he said. Now, however, the majority deemed negotiations leading to the execution of contracts admissible. So the trend has become unmistakably ominous, such that I must urge a halt. Don't want to let in preliminary negotiations because if the parties had intended that term to be in the contract, shouldn't they have written it down? And of course, the subjective theory has its supporters too. Justice Corcoran, writing for the Supreme Court of Arizona in Taylor v. State Farm Mutual, conceded courts do not have to listen to wholly unpersuasive extrinsic evidence when words are beyond dispute, but the purpose of contract interpretation is to produce the result that the parties intended, not what the judge intends. When words mean one thing to the parties and another to the judge, the court must consider the language and factual content surrounding the making of the agreement. The quote, "Admittedly," the court writes, "the process is not without risk, but we believe the game is worth the candle." In other words, it's worth the extra time and effort that a court will have to spend to arrive at the subjective meaning, because that's the point of contract interpretation. Well, there you have it. Compelling arguments on both sides. Is the subjective approach or the objective approach the better approach to contract interpretation? That's for you to decide. Now that we've learned where intrinsic evidence can be used to explain the meaning of an ambiguous term, and whether extrinsic evidence can show that a written agreement which is patently unambiguous actually has a latent ambiguity to it, we're now going to move on to a topic of when we can admit evidence, extrinsic evidence, to add or modify the terms of a written agreement, which is called the Parol evidence rule. And so join me for our next video to talk about the Parol evidence rule, which I'll do in a two-part sequence, and hopefully that will clear up one of the more confusing doctrines in contract law. So, thanks for tuning in. I'll see you next time.